Hearing in the appeal, the Queen against Reeves Taylor.
Yes, I suppose I should begin by saying that there are the normal reporting restrictions imposed on this unusual process, and also that, of course, the usual live streaming is not happening for the same reasons that there are restrictions on what can be reported in this sort of process. We hope that we're going to be able to make a recording so that your client can actually see what has been discussed here, but I'm not entirely sure whether we've managed to do that yet.
We're very grateful for that, my lady.
Well, if we have the equipment, we should be able to make our proceedings known to everybody who's involved in them.
Thank you very much. Yeah. That. My lady, my lords, may I please start with the appearances? I appear on behalf of the appellant, Dr. Reeves Taylor, with Ms. Eatwell and Ms. Cornelia, Mr. Perry of Queen's Counsel, Mr. Rogers, Ms. Howarth and Ms. Pottle appear on behalf of the respondent, and Mr. Swaroop of Queen's Counsel and Mr. Bethel appear on behalf of the intervener. The issue in this appeal is the proper meaning of the term person acting in an official capacity, as it appears in both Article 1 of the UN Convention Against Torture and Section 134 of the Criminal Justice Act 1988. And I will refer to them both, if I may, as UNCAT and CJA. We submit for the appellant that it applies only to those acting for or on behalf of a government of a state. The respondent and the intervener submit that it can be given an extended meaning. I have been allocated 3 hours for my initial submissions, 2.5 hours today and half an hour tomorrow morning. And we have 5 issues, and I propose breaking them down in this way. The first issue is the drafting history of UNCAT, which we say demonstrates that UNCAT was only ever intended to apply to those acting for or on behalf of a state. The second issue is the way that UNCAT has been interpreted by the Committee Against Torture in its general comments, in its reports to states, and in decisions on individual applications. The third issue is the position here in the UK, specifically in relation to Section 134 of the Criminal Justice Act, and how the official capacity requirement has previously been considered by the courts of this country, all of which we submit, with the exception of Zardad, either is supporting or consistent with the appellant's case. The fourth issue is the jurisprudence of the ICTY, the International Criminal Tribunal for the former Yugoslavia, which demonstrates that international humanitarian law and UNCAT are separate and distinct bodies of law, and importantly, how the jurisprudence of the ICTY, we respectfully submit, supports that UNCAT applies only to those acting for or on behalf of the government of a state. The fifth issue is the United States jurisprudence. Finally, and most likely tomorrow morning, we will offer some concluding remarks highlighting, in light of the analysis that we will go through today, why we say the scope of Section 134 of the Criminal Justice Act, articulated in Zardad and by the Court of Appeal in this case, is we respectfully submit wrong. So turning then to the first issue, the drafting history of UNCAT. We start with the drafting history of UNCAT because Section 134 of the Criminal Justice Act was enacted to implement the UK's obligations under the Convention Against Torture and enable the UK to ratify it. It was held in Pinochet No. 3 that the meaning of public official person acting in official capacity is the same under both Section 134 of the Act and Article 1 of UNCAT. At memory stick page 934, Lord Brown-Wilkinson states, in Pinochet, the first issue on the Convention is whether acts done by a head of state are done by a public official or person acting in an official capacity within the meaning of Article 1. He stated the same issue, the same question arises under Section 34 of the Criminal Justice Act. Crucially, he stated the answer to both questions must be the same. Moreover, in the Equality and Human Rights Commission and the Prime Minister and others, Sir Anthony May held at memory stick page 1090, paragraph 70, by Section 134 of the 1988 Act, the UK complied with its obligations under Article 4 of UNCAT and enacted the substance of the prohibition of torture as defined by Article 1 of UNCAT. It is therefore instructive, we submit, to consider what was intended by Article 1 of the UN Convention. The travaux préparatoires of UNCAT, we respectfully submit, make clear that the term any other person acting in an official capacity was only ever intended to apply to state actors or those acting on their behalf. Before considering that, it may be helpful to set out a brief overview of the Convention, which is set out in Authorities Bundle 1, tab 4, commencing at memory stick page 272. Article 1 defines torture as the intentional infliction of pain and suffering with a view to achieving a wide range of purposes when such pain or suffering is inflicted by or at the instigation, consent or acquiescence of a public official or other person acting in an official capacity. Article 2, subsection 1, requires that each state party to prohibit torture on territory within its jurisdiction, and Article 2.2 makes this a non-derogable right. Article 3 prohibits non-refoulement, extradition, to a state where there are substantial grounds for believing there is a danger of torture. And Article 4 requires each state's party to ensure all acts of torture are offences under its criminal law. Article 5 provides for universal jurisdiction for torture, A, when committed in its territory, B, by a national of that state, C, in certain circumstances when the victim is a national of that state, and secondly, provides for jurisdiction over any alleged offender found within its territory. Article 6 requires states in whose territory an alleged offender is found to detain, inquire into the position, and notify the states referred to in Article 5.1 and to indicate whether it intends to exercise jurisdiction. Article 7 sets out the requirement to either extradite or prosecute, and Article 8 makes torture an extraditable offence. Article 10 provides a non-exhaustive list of those whose states parties must ensure training regarding the prohibition against torture, and this includes law enforcement, civil or military personnel, medical personnel, public officials, and others who may be involved in custody, interrogation, arrest, and detention. Article 17 establishes a committee against torture, and Article 19 provides that it may receive reports from states parties on the measures undertaken by them under the Convention, and each report considered by the committee upon which the committee may comment. Article 22, if a state party recognises competence, allows the committee to receive individual petitions. So that's the overview of the Convention. In relation to the travaux préparatoires...
I'm sorry, can I just ask one question? If we go back to Article 1 for a moment, the definition of torture, we see first the nature of the act, any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person. And then if we skip the intervening part, we then see the words on which you focused, by or at the instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity. Now, the words I omitted in the middle have to do with the purpose to which the suffering is inflicted. for such purposes as obtaining from him or a third person information or a confession, punishing him, or intimidating or coercing him, or for any reason based on discrimination. Now, in the Criminal Justice Act, one sees, this is on MS 242, the definition in subsection 1, a public official, the same elements, public official or person acting in an official capacity commits the offence of torture if he intentionally inflicts severe pain or suffering on another, and then we have the equivalent of the purpose provision, in the performance or purported performance of his official duties. So the UK Act doesn't go into the same level of detail as Article 1 does by specifying particular purposes, but it has to be done, the pain has to be inflicted in the performance or purported performance of official duties.
My Lord, yes. And there is no definition of official duties in the Act. And when I come onto the third issue that I propose to deal with, we will respectfully submit that official duties must pertain to those acting for or on behalf of a state, and by virtue of the official duties being carried out by a public official or person acting in an official capacity.
Thank you.
In relation to the travaux preparatoires, the high point for the respondent, we respectfully submit, and the only reference in their written case in support of the position that the travaux support the wider interpretation advanced by the respondent, is set out at paragraph 118 of Novak and MacArthur's commentary on the UN Convention. Paragraph 118 of Novak and MacArthur's commentary is at tab 24 of the first bundle, and it's set out at memory stick page 597. In paragraph 118, Novak and MacArthur claim that the term goes beyond state officials and was inserted on the proposal of Austria to, they claim, meet the concerns of the Republic of Germany that certain non-state actors whose authority is comparable to government authority should be held accountable. Novak and MacArthur then go on to state, these de facto authorities seem to be similar to those political organisations which, according to Article 7.2i of the ICC statute, can be held accountable for the crime of enforced disappearance before the International Criminal Court. They say one might think rebel, guerrilla or insurgent groups who exercise de facto authority in certain regions or of warring factions in so-called failing states. The first point in relation to that is if one looks at Article 7.2i of the ICC statute, which is at tab 6, memory stick pages 298 and 299, we will see that Article 7 relates to crimes against humanity committed as part of a widespread or system attack directed against any civilian population. Article 7.1f has the crime of torture, and Article 7.1i relates to enforced disappearance of persons. And a definition of enforced disappearance of persons is set out on memory stick page 299 in subsection 2 of Article 1. And there we have the terminology articulated by Novak and MacArthur in paragraph 118. It's curious, we respectfully submit, that analogy is drawn from a crime that is not torture and is distinct from torture when torture is contained within Article 7.1. That's the first point. The second point is that when we go on to look at the underlying material cited by Novak and MacArthur in support of the proposition that they set out at paragraph 118, and it's set out at footnote 198, they rely on the material there to substantiate the view that Article 1 goes beyond state officials in the way they describe. But when one looks at the underlying material, we respectfully submit that it in no way supports the position advanced in the text.
Am I right in thinking that the crime of torture in Article 7(1)(f) is a distinct offence from that with which we're concerned?
It is, my lord, yes. It's a distinct offence because in order for it to amount to a crime against humanity under the International Criminal Court statute, it needs to be committed as part of a widespread or systematic attack. Torture also appears in Article 8 of the International Criminal Court statute as a war crime, whether committed in internal or international armed conflict. And again, we would respectfully submit that that is distinct from torture as it arises under UNCAT, because that torture can only be committed in or during the course of an armed conflict, either internal or international. Turning then to footnote 198, which is set out at memory stick page 607. Footnote 198 refers to section 22.2 above of Novak and MacArthur's own work, and Wendland.
Which footnote?
Footnote 198, which is the footnote in paragraph 118 to substantiate the view articulated by Novak and MacArthur. They refer to their own work and Wendland at page 29. Wendland at page 29 is set out at memory stick, in tab 28, memory stick page 665. And we see there, Wendland states, despite lengthy discussion, the working group drafting the convention was unable to decide upon a definition of the term public official. Both the United States of America and the Federal Republic of Germany proposed that the term be defined. Germany felt in particular that it should be made clear that the term public official contained in Article 1 refers not only to persons who, regardless of their legal status, have been assigned public authority by government organs on a permanent basis or in an individual case, but also to persons who, in certain regions or under particular conditions, actually hold and exercise authority over others and whose authority is comparable to government authority. In support of that, there are two footnotes in Wendland, footnote 58 and footnote 59. Unfortunately, the footnotes aren't included in the extract that's included at tab 28, but we can provide it if required. But I hope you'll take it from me for now that footnote 58 is the German proposal that was considered, was proposed during the negotiations on UNCAT, which is set out at tab 13, memory stick page 353. And footnote 58 is a reference to the work by Boulespa, Professor Arsène Boulespa, which is set out at tab 18 of the bundle, which, as we shall come to see, makes clear that the German proposal was not accepted. So the next thing I propose to do is to go to section 2.2 of Novak's work. Before doing that, it's perhaps convenient to briefly consider paragraph 116 of Novak and MacArthur, which is set out at memory stick page 597.
Could I just ask whether we get any indication as to the sequence of events so far as the Austrian amendment and the German concern are concerned?
My Lord, we will, and we will see that the Austrian proposal came some 1 month before the German proposal. I can take you to it now.
No, if you're coming to it in due course, that's fine. Thank you.
Certainly will come to it.
598?
598 6.
6, thank you.
596 going over into 597. And this is paragraph 116 of Novak and McCarthy. And the relevant part is on page 597. And it sets out the German proposal did not go as far as France, Panama and Spain, who advocated an extension of Article 1 to cover private individuals, but that Germany wished to include also non-state actors who exercised authority over others and whose authority is comparable to government authority. Novak and MacArthur note that since other governments, including the United States, the United Kingdom, Morocco, and crucially Austria, that since those states insisted on a traditional state-centred definition, the working group finally agreed on a US compromise which extended state responsibility to the consent or acquiescence of a public official. And they go on, since the delegations could not agree on the definition of public official, the Austrian proposal to add the phrase or other person acting in an official capacity was adopted. I've alluded to it already. The Austrian proposal was made within the context of the Austrian delegation insisting on a state-centred definition. Plainly, we respectfully submit, it was never intended that the official capacity requirement proposed by Austria was ever intended to extend to non-state actors unless, under the extended US proposal, they were acting with the consent or acquiescence of a state.
Yes. Is there other evidence than this to show that Austria's intention was as stated here? Because I think the domestic legislation that Austria eventually enacted was in fact broader.
It was, and it was in 2013, if I'm not mistaken, that legislation, that broader legislation was brought in.
So you say it's way after the event?
Way after, and if it was a matter of pressing concern for Austria, one would have thought that they would have done it very soon after rather than leaving it, a few decades.
Yes, I see, thank you.
Rather than going to section 2.2 of Novak and MacArthur, which is set out at tab 24, memory stick pages 578 to 580, paragraphs 30 to 40, all it does is summarise the various travaux preparatoires. So rather than look at the Novak and MacArthur summary, I would submit that it's perhaps preferable go to the actual records of the discussion, which are set out at tabs 11 to 17 in Bundle 1. The first document is set out at tab 11, which are the comments on the draft articles at the 35th session of the UN Economic and Social Council. And this goes to the date issue that was brought up earlier. These records relate to the proposals were made at this session up and until, if we see it at memory stick page 323, paragraph 6, it states that this report summarises the comments received as of 12th of December 1978. Memory stick page 326 sets out the draft article that was under consideration. You'll see there that it refers only to a person acting, refers only to public official, and there's no reference to any other person acting in an official capacity. That obviously came later. At memory stick page 327, at paragraph 29, we have a US comment, and it said that in this definition, i.e. the definition of the draft articles at page 300, memory stick page 326, in this definition it was stated torture is limited to conduct by or with the consent or acquiescence of a public official the public official concept is retained to broaden acceptance of the Convention by dispelling fears of international criminal law attempting to encroach on traditionally domestic concerns. Where there is no public official involvement of any kind, it is highly probable that the torturer will be apprehended and punished under national laws. In this context, an international convention is unnecessary. However, the United States proposes the concept of acquiescence of a public official rather than instigation by, so that public officials have a clear duty to prevent torture. The Austrian proposal is set out at memory stick page 330, paragraph 43, and we see there that Austria submitted that the concept, with regard to the concept of public official, the Austrian government believes that this concept should be expanded, for example, by using the words person acting in an official capacity. At paragraph 44, the Spanish government referred to the public official functionario public being too vague. At paragraph 45, another comment by the United States, public official should be defined to make clear that it relates to both civil and military officials. And those are all the relevant comments as of that date in December 1978. At tab 12, we have the UK proposal, which was made on the 18th of January 1979, and the UK proposed at paragraph 3, memory stick page 349. In order to amplify the definition, it is suggested that after public official, in the third line of paragraph 1, the phrase or any other agent of state should be inserted. We then go to tab 13, which sets out the German proposal, which was received on the up to the 31st of January 1979, so considerably after the Austrian proposal. And the German delegation stated, since the draft convention establishes legal obligation for states, the term should be defined and distinguished as precisely as possible from the marginally different term cruel, inhumane, degrading treatment or punishment. And then there's the paragraph which we cited earlier when we looked at Wendland in relation to the German proposal. In relation to that German proposal, may I make 3 observations? First, even the expansive proposition advanced by Germany anchored it to the fact that the convention, as we see at the top of the paragraph 2, anchors it to the convention establishing legal obligations for states. Moreover, the German position refers to authority comparable to government authority, or where it has replaced government authority. The second point is the comment clearly came after the Austrian proposal. So the Austrian proposal was not made to meet the German concern, as incorrectly suggested by Novak and MacArthur. And the third point, plainly, it wasn't accepted. The next important document is at tab 14, memory stick page 454. This is the report of the working group, and we see on the first page of the document the chairman rapporteur is Mr. Burgess of the Netherlands, who was one of the co-authors of Burgess and Danelius's commentary on the UN Convention.
Sorry, which is the...
It's
354.
354, my lady, at tab 14. And at page 6, paragraph 6, memory stick page 356, we have the draft article to emerge from the previous round of negotiations, and we see there that the term other person or other person acting in an official capacity has been inserted on the proposal of Austria.
Just because the Austrian proposal preceded the German one, does it follow that the adoption of the Austrian proposal was not in order to accommodate the Germans?
Well, we can't exclude that possibility.
No, okay.
Nowhere is that specifically articulated in
No.
any of the Travaux Preparatoires.
Thank you.
The only articulation of that is in Novak and MacArthur's work. Paragraph 26 at memory stick page 360 on the need for universal jurisdiction. It doesn't identify which delegation, but Burgess, the chairman rapporteur, records universal jurisdiction was intended to primarily deal with situations where torture is a state policy.
Sorry, paragraph?
Paragraph 26, my lord.
Thank you very much.
Where torture is a state policy, and therefore the state in question does not, by definition, prosecute its own officials who conduct torture. For the international community, to leave enforcement of the convention to such a state would be essentially a formula to do nothing. Therefore, in such cases, universal jurisdiction would be the most effective weapon against torture, which can be brought to bear. It could be utilised against official torturers who travel to other states, a situation which is not at all hypothetical. It could also be used against torturers fleeing from a change in government if their state, if for legal or other reasons, extradition to that state would not be possible. First, we submit that universal jurisdiction is clearly there provided for situations where torture is anticipated as a state policy. And second, it is to be used against official torturers or where there is a change in government, i.e. those who were, or in some cases still may be, state or government officials. The same point is made at the report set out at tab 15, 25th of March 1983, at memory stick page 381, at paragraph 2021. Special Chairman Rapporteur records, most speakers were in favour of the principle of universal jurisdiction. To secure effectiveness of the convention, territorial jurisdiction would not suffice to punish torture effectively as a state policy under Article 1. And at tab 17, there's nothing of any relevance we respectfully submit in 9th of March 1984. At tab 17, we have the report of the Secretary General on the concluded convention, which sets out the comments of some states after the conclusion of the drafting of UNCAT. And we see, for example, at memory stick page 448, comments from Panama and Spain expressing, in the words of Novak and MacArthur, dissatisfaction that the draft of the convention ultimately adopted did not go far enough. Panama commented at memory stick page 448, paragraph 8, it is a matter of concern that the description of torture in the proposed Article 1 is limited to those or other person acting in an official capacity. That suggests, if performed by an individual civilian organisation or pseudo-religious cult, the acts described in this article would not be considered as torture.
So they were arguing for a much wider definition, which would include all private acts of torture.
They are, but plainly that hasn't been incorporated
Yes.
in the draft, which is why they're dissatisfied with the draft to emerge. Next, commentary on the Travaux Preparatoire that I respectfully refer to is that by Burgess and Danelius, which is set out at tab 19, memory stick page 492 onwards. As noted, Burgess was the chairman rapporteur of the working group, and in the words of the Court of Appeal, with greater knowledge of the discussions than is revealed in the exiguous report which survives. And if we turn to memory stick page 496, under the heading, The Essentials of the Convention, Principal Aim of the Convention, about halfway down the page is a paragraph that begins, a second aspect that has to be noted is that the Convention does not deal with cases of ill treatment which occur in an exclusively non-governmental setting. It only relates to practices which occur under some sort of responsibility of public officials or other persons acting in an official capacity. This makes clear, we respectfully submit, that the Convention was not intended to have any application in an exclusively non-governmental setting. At memory stick page 514, Burgess and Donnelly sum up the discussions on Article 1, and at the bottom of the page, at the very bottom of the page...
Sorry, which page?
514.
Thank you.
Memory stick page 514, and it's the second line up that commences, this is the commentary on the public official capacity requirement. In the end, it was generally agreed that the definition of acts committed by public officials should be expanded to cover acts committed by or at the instigation of or with the consent or acquiescence of a public official or any other person acting in an official capacity. Therefore, we submit that the expanded definition was achieved with the consent or acquiescence provision applying to public officials and those acting in an official capacity. That is the means and method by which the expanded definition was incorporated. At memory stick page 522, on the question of the identity of the perpetrator, Burgess and Donnelly note at the bottom of the page, the conclusion was, however, that only torture for which the authorities could be held responsible should fall within the Article's definition. If torture is committed without any involvement of the authorities, but as a criminal act by private persons, it can be expected that the normal machinery of justice will operate and that prosecution and punishment will follow the normal conditions of the domestic legal system. The Court of Appeal, in this case, attached significance to the use of the term authorities rather than states by Burgess and Donnelly. That's at memory stick page 226, paragraph 46. But if one looks at memory stick page, over the page in Burgess and Donnelly, memory stick page 523, we see there in the second paragraph, or the first paragraph to commence, the problem with which the Convention was meant to deal was that of torture in which the authorities of a country were themselves involved and in respect of which the machinery of investigation and prosecution might therefore not function normally. A typical case is torture inflicted by a policeman or an officer for the investigating or prosecuting authority. But many variations are conceivable. It could be that the torture is not directly connected with any public authority, but that the authorities have hired him to help gather information or have at least accepted or tolerated his act. All such situations where the responsibility of the authorities is somehow engaged are supposed to be covered by the rather wide phrase appearing in Article 1, inflicted by or at the instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity. But throughout this paragraph, we respectfully admit it is clear that when they are referring to authorities, they are referring to the authorities of a country. The next commentary on the Convention that we respectfully take you to is that by Professor Arsène Boulespa, which is set out at tab 18 at memory stick page 451. This is his work entitled The UN Convention and Prospects for Enforcement. At page 453, the scope of the Torture Convention, he states this chapter is part of a continuing effort to identify potential problem areas that the drafters of the Torture Convention failed to anticipate. The intention is to confront and to resolve legal ambiguities which could be used by states to circumvent their obligations as signatories to the Convention. At memory stick page 455, he states that the purpose of his work is clarifying and eliminating the deficiencies that exist in Article 1 of the Convention will make it far more difficult for states parties to justify torture or to rationalise their failure to prevent it. At page, he deals with the origins and evolution of Article 1 at pages 456 to 400 and memory stick page 460. At memory stick page 475, he considers the travaux preparatoires on the identity of the offender. We've been through that already, so I don't propose to go through it again. And at memory stick page 479, he deals with the travaux regarding the public official requirement and the suggestions made by Britain, the US, Germany, and notes that the German proposal was broader, and that's the proposal that we've looked at already. And at memory stick page 480, he notes, but these proposals were not incorporated in the Convention by the working group. At memory stick page 491, conclusion, he states that at the very top of the page, in relation to the definition of Article 1, the definition covers only intentional government conduct. It does not cover negligence of the government, nor does it apply to private individuals not acting on behalf of the government. Such features of the definition clearly limit the scope and effectiveness of the Convention. Now, that concludes our consideration of the travaux preparatoire. Noted, nowhere in that analysis do we see the extended definition of official capacity as articulated either by the Court of Appeal in this case or Mr. Justice Sweeney in the Court of Appeal or Tracy in Zada.
Do we find anywhere addressed the question of what happens in circumstances where there may be two bodies within the territory of the state purporting to exercise governmental functions?
No, my lord, but...
Only in that passage in Nowak and MacArthur?
Yes, but we would respectfully submit that in a state there can only really be one government. There's only one government of a state. There may be regional governments, but they will be all acting through the authority of the central government. So when we refer to government, we respectfully submit that refers to the government of a state, and all references to government in these works is referring to governments of a state, a central state. And we'll see that in more detail when we look at the comments of the Committee Against Torture and many of the decisions and general comments that they've made as well. And that's the second issue that I propose to come to.
So how is the question which of those bodies is to be regarded as the government of the state to be decided? Does it turn on recognition?
Well, in relation to the question of recognition of a government, we take a neutral position in relation to that in terms of whether that's important or not. If a government of a state is not recognised, and they are purported to be the government of the state, plainly in those circumstances, all the requirements and elements of a state will be present, and the issue will be whether the government or the state has been recognised or unrecognised, but plainly they'll be fulfilling all state-like qualities. It may be an important issue in another case, but we respectfully submit on the facts of this case, where we're dealing with the very early stages of a civil war, where the alleged offences are said to have taken place within the first 6 months of a civil war, where territory is changing hands quickly and there's a state of flux. The question of recognition or non-recognition of the government doesn't come into play at all. So, again, that is why we take respectfully submit a neutral position. Maybe an important issue in another case, but we submit it's not one in this case.
It may be that it does or does not arise in the particular circumstances of this case. That's something we'll have to come to. But can recognition ever be a relevant factor in circumstances where states have different policies on recognition? And this country doesn't recognise governments at all.
My Lord, absolutely, and recognition is very much a political act, which could be relevant in certain cases. But again, in this case, it doesn't arise on the facts of this case because there's no assertion that the area where these offences were taking place were dealing with the National Patriotic Front of Liberia, which is the organisation arising in this case, was in no way, shape or form at the level that it could or could not have been recognised as a government of the state of Liberia. At all times relevant to the offences in this case, there was a central recognised government in Liberia.
In other circumstances, recognition could therefore be relevant.
It could be in certain cases, and we take a neutral view in relation to that. If there's an intention to it may be relevant in some cases.
Thank you.
The second issue are the decisions and general comments of the Committee Against Torture. The respondent makes the point, citing Jones and Saudi Arabia, that the Committee Against Torture is not an exclusively legal body and not an adjudicative body. That's at paragraph 66 of their written case at memory stick page 118, referring to Jones at memory stick page 698, paragraph 23. But we respectfully submit that the decisions of the Committee Against Torture and the importance and the value of them is not limited just to the views expressed by the committee. It is also the submissions of the states to the committee on the scope of Article 1, particularly because those states would have been party to the proceedings and part of the negotiating process on the convention. All of the issues, all of the cases occur within the context of non-refoulement under Article 3.1 of UNCAT, that provides that no state party shall expel, return or extradite a person where there are substantial grounds for believing that the person would be in danger of being subjected to torture. And the first matter is the application of GRB and Sweden, which is set out at tab 49, memory stick page 1413, paragraph 6.5. And we see there that the committee, in considering the scope of torture under Article 3 in relation to non-refoulement, the committee states state parties' obligation to refrain...
Sorry, paragraph?
Sorry, 6.5.
Thank you.
6.5,
my lady. Page 1413, paragraph 6.5, at the bottom of the page, the last paragraph on the page. And the committee states that the state's party's obligation to refrain from forcibly returning a person to another state is directly linked to the definition of torture as found in Article 1 of the Convention. The committee, at the last sentence, the committee considers that the issues whether the state party has an obligation to refrain from expelling a person who might risk or pain of suffering inflicted by a non-governmental entity without the consent or acquiescence of the government falls outside the scope of Article 3 of the Convention and therefore by extension Article 1 as well. In GRB and Sweden, the threat of torture was posed by a group called Sendero Luminoso in Peru, a group unconnected to the state authorities. We see that at paragraph 2.3 at memory stick page 1407. And in a later case, it makes clear that Sendero Luminoso was in control of territory, significant amounts of territory within Peru. We'll come to that later when we deal with that case. The next case is SV and Canada at tab 54. And at memory stick page 1462, at paragraph 7.8, it said there that the state party, this is in relation to the threat posed by the LTTE in Sri Lanka, and we see there that Canada submitted the state party submits that acts committed by the LTT in Sri Lanka do not fall under the competence of the committee, since the definition of torture in the convention refers expressly to acts committed by or at the instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity. Acts committed by the LTTE, Canada submitted, cannot be attributed to the state and therefore are not covered by the convention. Now, I'll pause there if I say this. If the respondent is correct in their articulation of the scope of Article 1, you would expect that on hearing Canada's submissions and position, you'd expect the committee to reply, that's wrong because the convention also applies to, quoting the test advanced by the respondent, it also applies to those who act otherwise and in a private and individual capacity for on behalf of an organisation or body which exercises or purports to exercise the functions of government over the civilian population in the territory which it controls and in which the relevant conduct occurs. But you don't see that. What you do see is at paragraph 9.5 on memory stick page 1467, going over to 1468, and it's the paragraph just above paragraph 9.6. The committee's position was, after hearing Canada's submissions in relation to the limited scope of the convention, TTE, the committee considers that the issue of whether the state party has an obligation to refrain from expelling a person who might risk pain or suffering inflicted by a non-governmental entity, in this case the LTTE, without the consent or acquiescence of the government, falls outside the scope of Article 3. Consequently, the issue on which the authors base part of their claim, that they would suffer torture by the LTTE or other non-governmental entities on return to Sri Lanka, cannot be considered by the committee. The next case, which I can deal with quite quickly, is...
Is there anything in this decision which talks about whether there was part of the territory of Sri Lanka that was actually under the control of the LTTE, which clearly it was at certain times in its history?
.4.
Yeah.
2.4. In 1990, the LTTE took control of the Tamil region.
Yes, I mean the north, the Jaffna Peninsula, the north, north from Trincomalee, in effect, what was in the late 20th century under LTTE control.
Yeah.
Wouldn't it? I mean, the issue isn't so much whether they were in control at the time when he was previously in Sri Lanka, is it? But rather whether they are in control now, as at the time when he is proposed to be deported there.
Yeah.
It's both, my lord, but obviously it's at the point at which the person is due to be returned there. That it's crucial to the threat of torture by such a non-governmental group in the entity, in the words of the committee, falls outside the scope of the convention, and plainly the LTTE had a much more significant grip and control of territory, was a much more higher order in terms of control than exists on the facts of this case. But even that, in the committee's view, come within the scope of Article 1 of Convention.
Yes, and this decision was 1999.
Lord, yes. And in the MPS and Australia, another decision of 1999 at tab 52, I can deal with it quickly. It's the same point. Another case on the LTTE, the committee, recalling its previous jurisprudence and referring to GRB in Sweden, footnote 3, again, makes the same point. The pain or suffering inflicted by a non-government entity without the consent or acquiescence.
I'm sorry, you're going to have to give me that reference again.
I'm so sorry, my lord. It's memory stick page 1499, paragraph 7.4.
Did you say 1429?
1439. 1439.
Thank you.
Yes, paragraph 7.4, the last, the bottom part of that paragraph.
Thank you.
Australia was the respondent state in two cases in relation to Somalia, ELMI in 1989 and HMHI in 2002. Before looking at the earlier case of ELMI, it's perhaps worth considering the position of the Australian government in HMHI, which is set out at tab 50, memory stick page 1418, at paragraph 4.3. And
Sorry, this is ELMI or
this is
HMHI? Sorry,
HMHI at tab
50.
Tab 50, memory stick page 1418, paragraph 4.3, and Australia submitted. The state party submits that the communication is inadmissible ratione materiae on the basis that the convention is not applicable to the facts in the communication in a variety of respects. Firstly, the acts of the complainant, of the complainant alleges that he will face if he is returned to Somalia do not fall within the definition of torture set out in Article 1 of the Convention, which refers to acts involving a public official or other person acting in an official capacity. The state party also refers to the travaux preparatoires of the Convention for the proposition that torture for the purposes of the Convention requires the responsibility for the acts of torture to be attributable to the state. The committee agreed at page 1421, paragraph 6.4, the committee, citing GRB and Sweden again, stated that it considered the allegations of risk of torture at the hands of Sendero Luminoso in GRB in Switzerland, a non-state entity controlling significant portions of Peru, fell outside the scope of Article 3 of the Convention. So it's clear we respectfully submit that even where a non-governmental group controls significant territory in a country, unless they're acting with the state, it falls outside the scope of the Convention. The committee then goes on to consider and distinguish ELMI in Australia and say, in ELMI in Australia, the committee considered that in the exceptional circumstance of state authority that was wholly lacking, acts by groups exercising quasi-governmental authority could fall within the definition of Article 1 and thus call for the application of Article 3. They went on. But with 3 years elapsing since the ELMI decision, Somalia currently possesses a state authority in the form of the Transitional National Government, which has relations with the international community in its capacity as a central government, though some doubts may exist as to the reach of its territorial authority and its permanence. The committee concluded that it did not consider this case to fall within the exceptional situation in ELMI and takes the view that the acts of such entities, as are now in Somalia, fall outside the scope of the Convention.
Mr. Powles, when we read all these committee decisions, obviously in our mind's eye, we're comparing, seeking to compare the factual situations there with the factual situation with which we are presented and upon which we have to make our decision. Is it right that the factual situation upon which we are invited to make our decision is paragraph 12 of the Statement of Facts and Issues?
Yes, my lord, it's not just paragraph 12. There are slightly, there's, well, the relevant facts are set out from paragraphs 5 onwards. In relation to this issue, paragraph 7, remember stick page 50, the appeal arises from a preparatory hearing, as such none of the facts below have been adjudicated. The allegations arise within the context of the early stages of the First Liberian Civil War, when an armed group called the National Patriotic Front sought to take control of the country and depose the then President Samuel Doe. Then at paragraph 9, the respondent's expert claims that by June of 1990, the MPFL had advanced and surrounded the capital Monrovia and was in de facto control of 80% of the country. At paragraph 10, the respondent's expert acknowledges that identifying a specific date when a particular town fell under MPF control is difficult. Territory changed hands quickly during the early months of the war, and both the MPFL and the government of Liberia made misleading statements about which towns were under their control. And then there's paragraph 12, served by the respondent after the hearing in the Court of Appeal, in which the respondent's expert clarified that his use of the term control in his report referred to military control rather than administrative control.
Now, this was served after the hearing.
Yes.
Did the Court of Appeal see it before it gave judgment?
It wasn't provided to them by us. So
Sorry?
it wasn't provided to them by us. As far as I'm aware, no, they weren't.
I see. No.
But none of this has been adjudicated upon.
My lady, no. Well,
This is one of the problems with this procedure, isn't it? What are we to do? Are we to proceed on the basis of what the law is if the facts are as stated in the SFI? Or are we to proceed on the basis that it is now back to the trial court to decide whether the facts are indeed as stated in the SFI or something else, so that it's all up for grabs by a jury? I mean, you would say on these facts there's no way the Act applies, and so that's the end of the matter. But supposing somewhere else we might reach some intermediate conclusion as to what the law is, then it all goes back and it's for a jury to hear the evidence and decide?
Well, my lady, of course, this issue arose within the context of a preparatory hearing before Mr. Justice Sweeney. So that would be the first issue. But our respectful submission and our position is, of course, that the Act and Article 1 of the Convention doesn't apply in any way, shape or form to non-government entities who are not acting for or on behalf of the government of the state. If that's right, and I think the respondent would agree, if that's right, this case does go away. And I think that was very much the understanding when this point was litigated at first instance before Mr. Justice Sweeney, that if we're right in the interpretation that we put forward, then there is only one way forward for this case.
Well, your position is that it's got to be state authority. Query whether it's got to be recognised as a state, but probably not, in fact. But your position is state authority. The respondent's position is governmental authority of some shape or form. But clearly, governmental authority is a very amorphous concept and might require further definition. And if that were the case, that would have to go back for all the facts about the true situation in Liberia at the relevant time to be investigated before the jury, and for the jury to have questions about whether or not what was being done as part of governmental authority. Is that Is that the situation?
Well, Melinda, of course, very
You don't have to answer that question now, can think about it. Mr. Perry can answer it, but I'd still like to know what your answer is.
well, may we reflect on that then?
Yeah.
As
I mean, it's
well.
really very seriously important for the conduct of these proceedings.
Lady, yes.
Supposing we don't go 100% in your favour, what does happen next?
Speaking for myself, I would find it helpful to be referred to the legislation under which these proceedings are taking place. I'm not sure if we're presented in the SFI with effectively the Crown case as set out apparently by their expert witness. I'm not sure if we're being asked to do something rather like something like a no case to answer submission here in advance of a trial, or whether we're simply being asked to rule on a question of law. And I presume the legislation under which this procedure takes place will clarify that.
Lord, we would respectfully submit it's the latter, that what we seek from this court is an indication of what the correct scope of the law is, and that can then be applied thereafter by the appropriate tribunal, whether it is Justice Sweeney or whether it is a jury. It is perhaps a matter for another day, but I take your point, my lord, and of course these proceedings are brought pursuant, as an interlocutory appeal, pursuant to the Criminal Justice and Procedure Act 1966, so we can provide the relevant provisions. I respectfully agree that of course would be helpful. I think I was just about to come on to the case of Elmi and Australia, which was decided some 3 years before HMI and Australia. Before doing that, it's clear from HMI and Australia, we respectfully submit that the key feature in Elmi, as articulated in HMI, what gave rise to the exceptional circumstance in the mind of the committee, was the lack of a central government in Somalia at the time that Elmi was decided. And so much is made clear, we respectfully submit, by the decision in it, which is at tab 48, memory stick page 1402, at paragraph 6.5, where the committee noted that for a number of years, Somalia has been without a central government, that the international community negotiates with warring factions, and that some of the factions operating in Mogadishu have set up quasi-governmental institutions that are negotiating the establishment of a common administration. It follows then that the de facto, those factions exercise certain prerogatives and are comparable to those normally exercised by legitimate governments. Accordingly, the members of those factions can fall, for the purposes of the application of the Convention, for the purposes of the application of the Convention within the phrase public officials or persons acting in an official capacity contained in Article 1. So, essentially, there are three important things. First, the groups concerned had set up quasi-governmental institutions negotiating the establishment of a common administration. Two, they were exercising functions comparable to those normally exercised by legitimate governments. And three, crucially, we respectfully submit, there was no central government. Elmi and another Australian case of MKM were cited by the Committee Against Torture in General Comment number 4.
If you're going to move on, could I just ask, is it the position then that you accept that if there's no central government, then a group of insurrectionaries purporting to perform the functions of government in a part of the territory of the state would be official acts, or could be official acts for this purpose?
That's the key question, and that is determined by the fact that there was no central government, and the importance of that is the point I propose to come on to now when looking at other decisions and general comments. It makes clear that within the scope of the Convention, the lack of a central government, or rather, let me put it another way, if there is a central government, it's impossible for the actions of non-state actors to fall within the scope of Article 1 for the purposes of the Convention. So it's perhaps putting it the other way around. if there is a central government, for the reasons that I'll come on to, it's impossible for the actions of non-state actors to fall within the scope of the Convention. ELMI and MKM in Australia are cited by the Committee Against Torture in General Comment number 4 on the implementation of Article 3 of the Convention, which is set out at tab 56, memory stick page. The relevant page is 1484, paragraph 30, which deals with the application of Article 3 and non-rule for more to non-state actors. And the committee states that states parties should...
Sorry, paragraph?
Sorry, paragraph 30, my lord, at the top of page 1484. States parties should refrain from deporting individuals to another state where there are substantial grounds for believing that they would be in danger of being subjected to torture or other ill treatment at the hands of non-state entities, including groups that are unlawfully exercising actions that inflict severe pain or suffering for the purposes prohibited by the Convention, and over which the receiving state, and that we respectfully submit is important, and over which the receiving state has no or only partial de facto control, or whose acts it is unable to prevent, or whose impunity it is unable to counter.
That's a different situation from that contemplated in ELMI, isn't it?
My lord, yes.
It's addressing the situation where, it includes the situation where you've got two or more entities exercising governmental functions within the territory of the state.
It includes, in the committee's mind, a situation where a state, who is the state party to the Convention, is in a position to exercise partial control over the territory and prevent or otherwise impunity in the state concerned. And our respectful submission is, if there is a receiving state or a central government, then it is their responsibility and it is their role and actions as the state that triggers the application of Article 1 and puts the actions of the non-state actor within the ambit of the Convention. It is not the conduct of the non-state actor itself that falls within the scope of Article 1 and the ambit of because the two decisions that the Committee Against Torture cite at footnote 58 in support of this proposition, at footnote in 58, there's reference to ELMI, which we've just looked at, paragraphs 6.8 and 6.9, and the other Australian decision of MKM and Australia.
Ought we to look at that? Just tab 51?
Just tab 51. Perhaps before doing that, may I make two observations? Our position is that in non-reformant cases, the determinative issue is the state's obligations under Article 3, namely the obligation not to return someone to a state where the authorities of that state either pose a risk of torture or where the authorities of that state will be unwilling or unable to prevent or protect the person from torture. It is that puts the issue within the ambit of the Convention. But the inability to prevent acts of torture by non-state actors is not a constituent element of the definition of torture in Article 1. General comment number 4, the Committee Against Torture is not saying that torture by non-state entities falls within Article 1, the Article 1 meaning of torture. It can't, because as we've already seen, the conduct of such groups does not fall within the scope of Article 1. What the CAT is seeking to ensure is protection in non-reformant cases by highlighting the obligation of the receiving state, because it is them as the state that has obligations under the Convention. And with that in mind, may I then come on to MKM and Australia, which is at tab 51, memory stick page 1423. In MKM in Australia, at paragraph 2.7, memory stick page 1424, the complainant feared abuse by the Taliban. Paragraph 2.8, memory stick page 1425, the complainant submitted that if he returned, he would not be able to, as a failed asylum seeker, get effective protection against threats to life by non-state actors. And in relation to a consideration of the merits at paragraph 8.7 at 1431, the committee stated that it is aware of the human rights situation in Afghanistan. The committee further notes the complainant's claim that he was subjected to torture by non-state actors and that the state party would not be in a condition to protect him if returned to Afghanistan. In that connection, the committee recalls that it has in its jurisprudence and in its general comment number 2, 2008, which I'll come to in a moment, on the implementation of Article 2, addressed the risk of torture by non-state actors and the failure on the part of the state party to exercise due diligence to intervene and stop abuses that are impermissible under the Convention, for which it may bear responsibility, namely the state party. We submit, therefore, that what puts the conduct of non-state actors within the ambit of the Convention is the failure of the state to intervene. It is the state, by virtue of its failure to exercise due diligence, that engages UNCAT, not the conduct of the non-state actor. And again, we'll see that when we look at general comment number 2. Paragraph 8.8, memory stick page 1432, the committee considers undisputed the fact that the complainant has been detained and tortured by the Taliban. Paragraph 8.9 on the same page, the committee therefore considers that by rejecting the complainant's asylum application without giving sufficient weight to the fact that the Afghan authorities are not in a condition to protect the complainant from further persecution by the Taliban, the state party failed to investigate sufficiently whether the complainant would be in danger of being subjected to torture or treatment if returned to Afghanistan. Again, the determinative feature is the receiving state authorities not being in a condition to protect the individual. And with that in mind, then, may we look at general comment number 2 at tab 55, memory stick page 1471. As we noted earlier, Article 2, subsection 1 requires each state's parties to take effective legislative, administrative, judicial or other measures to prevent acts of torture in any territory under its jurisdiction. Paragraph 15, memory stick page 1472, going over on to 1473. At paragraph 15, the committee states in general comment number 2, the Convention imposes obligations on states parties, not on individuals. States bear international responsibility for their acts or omissions of their officials and others, including agents, private contractors, and importantly, and others acting in an official capacity or acting on behalf of the state in conjunction with the state under its direction or control or otherwise under the colour of law. We respectfully submit that that makes clear that the term official capacity is directly linked to those acting for or on behalf of the state. Paragraph 16 on memory stick page 1473, the committee states that Article 2.1 requires that each state's party shall take effective measures to prevent acts of torture not only in its sovereign territory, but also in any territory under its jurisdiction. The committee has recognised that any territory includes all areas where the state party exercises directly or indirectly, in whole or in part, de jure or de facto effective control in accordance with international law. Therefore, the obligation applies even where, say for example in a civil war, the state does not have military control over an area, and as the obligation applies even where the state party only partly exercises de facto or de jure control, even in a situation of civil war, the state exercises de jure control at all times.
Which paragraph was that?
This is paragraph 16.
Thank you.
My Lord. Those are my comments on paragraph 16. That's not contained within paragraph 16. But that is where we derive those principles from. And that, we respectfully submit, is the ELMI and HMI distinction. Because in circumstances where there is a central government in existence, notwithstanding, as the committee noted in HMI, notwithstanding doubts as to its territorial reach, it is that government that has responsibility to protect all from torture, including the risk of torture by non-state actors. Paragraph 17, the committee observes that states parties are obliged to adopt effective measures to prevent public authorities and other persons acting in an official capacity, again, official capacity, from directly committing, instigating, inciting, encouraging, acquiescing, or otherwise participating or being complicit in acts of torture as defined in the Convention. Going on, the committee has concluded that states parties are in violation of the Convention when they fail to fulfil these obligations. For example, where detention centres are privately owned, the committee considers that the personnel are acting in an official capacity. Again, we respectfully submit that delineates what acting in an official capacity constitutes. It's where those are, even private actors are acting on behalf of the government of a state, because they go on to say they're acting in an official capacity on account of their responsibility for carrying out the state function without derogation of the obligation of state officials to monitor and take all effective measures to prevent torture or ill treatment. We submit makes clear that what gives rise to someone acting in an official capacity within the meaning of the Convention is their carrying out state functions, even if they are not public officials. And that is why the term persons acting in an official capacity was included in Article 1 to cover those persons who are acting on behalf of the state in an official capacity, even though they are not public officials.
I wonder whether it's necessary to distinguish here between the state's own failure to take action to prevent torture, which is a matter of the state responsibility of the state, necessary to distinguish that from the distinct question as to the liability, criminal liability of a non-state actor. That is the scope of the offence committed by an individual created by the Torture Convention.
No, my lord, because we respectfully submit the criminal liability for a non-state actor can only arise within the jurisdiction of the state where the torture has taken place. It cannot fall within the scope of the Torture Convention and Article 1 of the Convention, because Article 1 is, my lord, Article 1 sets out the meaning of torture for the purposes of the Convention. Once that is the prism through which you have to go to determine the ambits of the Convention and the scope of the Convention. If Article 1 only applies to those acting in an official capacity, it's for that reason that we say it can only apply to those acting for on behalf of the state. And their criminal liability under the Convention, within the meaning of Article 1 of the Convention, only applies to those individuals. Non-state actors and their criminal liability arises under the domestic law of the state where the alleged conduct takes place.
But are these not distinct matters? State responsibility on the one hand, liability of individuals on the other?
Lord, they may be, but in relation to the liability of individuals, the criminal liability of individuals can only, our case, we may be wrong, yes. Our case is that the criminal liability of individuals under the Convention can only arise through the prism of the scope of Article 1. And if Article 1 and torture within the meaning of the Convention doesn't cover non-state actors and only applies to criminal conduct of those who aren't acting on behalf of the state doesn't fall for consideration under this Convention at all. Paragraph 18 regarding non-state officials, the committee has stated that the committee has made clear that where state authorities or others are acting in an official capacity or under colour of law, know or have reasonable grounds to believe that acts of torture or ill treatment are being committed by non-state officials or private actors, and they fail to exercise due diligence to prevent, instigate and punish such non-state officials or private actors consistently with the Convention, the state bears responsibility and its officials should be considered as authors, complicit or otherwise responsible under the Convention for consenting to or acquiescing in such impermissible acts.
In relation to the point you just raised, is your argument that if you construe Article 1 in the way in which the Crown would construe it, then Article 2 would impose an obligation on state parties to perform the impossible in a situation where they're not in de facto control of the territory where torture is being carried out?
It may be impossible at that time, but it doesn't mean to say that the responsibility doesn't still fall and land on the door of the state.
Well, can you help me? How does a state party comply with its obligation to take effective measures to prevent acts of torture in territory under its jurisdiction if it's not actually, in reality, in control of that territory?
That the state has got, there's a distinction between a situation where a state cannot or decides not to intervene. If the state decides not to intervene, then of course they are consenting or acquiescing. But if they're unable to intervene, that is a separate issue. The important point is state authorities or others acting in an official capacity become the author of the act of torture where they know or have reasonable grounds to believe that torture is being committed and they fail to exercise due diligence. This is akin to a state being unable this is akin to a state being unwilling to act or acquiescence by a public official or a person acting in an official capacity, an element of the definition of torture within the meaning of Article 1 of the Convention. It's clearly distinct from an inability to act. A state's inability, in the circumstances which my Lord raises, a state's inability to act does not amount to torture within the meaning of Article 1, as this does not, when you look at the parameters of Article 1, torture only arises where the state's instigation, acquiescence or consent to an act of torture. But if a state is unable to act in a given situation, it is not instigating, acquiescing or consenting in the act of torture by the non-state actor. Therefore, the act of torture by the non-state actor doesn't fall within the scope of the Convention.
Well, I think the way you put it rather begs the question. The question is whether the phrase "a public official or other person acting in an official capacity" could encompass somebody acting in a quasi or de facto governmental role in territory which is under the de facto control of the organisation to which that person belongs. And that's the issue. And there's a general principle of interpretation, at least in our domestic law, that the law doesn't require the performance of the impossible. If you construe Article 2 as on the basis that Article 1 defines torture in the way we've just discussed, then Article 2 would impose on each state party an obligation to take effective measures to prevent acts of torture in any territory under its jurisdiction. Acts of torture, that's to say, by people who were in de facto control of that territory and and in a situation, therefore, where the state party couldn't, in reality, possibly prevent the torture. That might be thought to be a rather implausible interpretation of the Convention.
My Lord, no, because the conduct of those non-state actors still falls within the domestic law of the state where that conduct occurs. Whether or not the state at that time can do anything about it, that is not what gives rise to the application of Article 1. It is the prism through which the whole of the Convention operates.
Yeah, I think we're speaking past each other. I don't think you understand the point I'm trying to make.
My Lord, well, perhaps we'll reflect on that and perhaps address that point in the remaining half an hour that we have tomorrow morning. But
yes, in paragraph 18, to which you referred, the passage you read out to us just before this exchange with Lord Reed, where it says the state authorities who have reasonable grounds to believe that non-state actors are committing tortures have certain obligations. Which article in the Convention gives rise to that jurisprudence? Is it Article 2?
My Lord, yes. It's Article 2, which...
It's 2.1.
2.1,
we've just been looking at.
My Lord, yes.
Thank you.
But Mr. Powles, we've been looking at so many statements this morning to the effect that the Convention people were saying, well, we're not going to deal with torture that the government can deal with. We're not going to deal with individuals. The government must deal with it. Well, in this particular case, there's Mr. Doe, the president of Liberia. He wouldn't be able to deal with the alleged torture being committed here. So is that not rather a reason for thinking that the construction should be in favour of including the de facto situation?
Lord, we would respectfully submit not, because the conduct of those non-state actors is effectively the conduct of a private individual, someone acting in a private capacity rather than acting in a public official or official capacity as required under Article 1. And that private conduct plainly doesn't fall within the scope of the Convention. It may create situations where the domestic state can't deal with it, but the consequence of the domestic state not being able to deal with it doesn't give rise to that amounting to an act of torture within the definition of the Convention, and therefore the universal jurisdiction applying. To perhaps use an analogy, if a husband and wife at home, and a husband is torturing his wife, that plainly is something happening within a private capacity. It could never come within the meaning of the Convention. If a state is unable to prevent that at any one given time, that inability to deal with that situation is not what makes that act of torture come within the definition of torture in Article 1 of the Convention, which must be carried out by a public official or person in official capacity. So whether it's a private individual at home or a non-governmental group, even if they control a significant amount of territory within the state, the principle is exactly the same. Just because the state can't deal with it at that time doesn't make the action of either the husband and wife at home or the armed opposition group come within the definition of torture as contained within Article 1 of the Convention.
Thank you.
Situations which you postulate is that the rebel group is purporting to perform the functions of government.
Well, respectfully, we would submit that they're not. They're not purporting to commit functions of a government. They're particularly on the facts of this case.
Well, we may have to deal with a distinct theoretical case. I think there's a problem about the facts of this case that my lady has already drawn attention to. That has to be resolved in the course of the appeal. But if you have a body which is a rebel organisation within the territory of the state, which has the intention of overthrowing the government, and at this stage has established its control over part of the territory of the state and is ostensibly purporting to exercise the functions of government, why should those acts not be considered to be official acts?
Because we would respectfully submit they're not being carried out by public officials. They're not being carried out by state officials, which is we've looked at the Travaux Préparatoire and all the decisions of the Committee Against Torture, they all make, we respectfully submit, very, very clear that it's only governmental authority that falls within the scope of the Convention, or those who situations where the government consents to acquiescence in the conduct of non.
So you say it can't be governmental authority unless it's attributable to the central government, the legitimate government, the recognised government.
We're really arguing about whether there's a difference between the state and the government. You say it's got to be the state. The respondents say it's got to be governmental in nature.
We would respectfully submit within the context of this bill, they're one and the same. The government and the state, we're using the terms interchangeably. It's the government of the state, and either the state party or the government of that state party. So to that extent, we submit that there is perhaps not too much of a distinction between the term government or state. In our written case, we refer to Article 1 of the Convention applying to the acts of a government of a state.
You do? Yes.
We could have dropped the term government of a state and simply used the term state, because we respectfully submit that the two go hand in hand together. When we use the term government, we mean the government of a state.
Yes, I understand that's what you mean. And the Court of Appeal took the view that you could drop the state bit of that and just have government.
Well, we would respectfully submit that the Travaux Préparatoire don't support that conclusion, and all the decisions of the Committee Against Torture similarly don't give rise to that conclusion under the Convention. And it may be, as we see when we look at some of the domestic jurisprudence on this issue, that the position is very much the same when Article 1 has been considered by the courts of this country. So with that in mind, it may perhaps be appropriate for me to move on to the third issue in our submissions, which is the position in the UK under section...
Could I just ask you about SS, which is one of the
yes.
decisions of the Committee on Torture we haven't been to?
My Lord, yes. That's at tab 53, memory stick page.
Thank you very much.
1441.
And there's a passage at 6.4 in SS, on which you might be able to help us.
My Lord, yes. It's at memory stick page 1450, and the committee in its decision, referring at footnote 10 to ELMI, MPS and SV and Canada, which we've already looked at, and in which, in SV and Canada, the committee held that torture by the LTT was not within the scope of the of Article 1. The committee said the issue whether the state party has an obligation to refrain from expelling a person who might risk pain or suffering inflicted by a non-governmental entity without the consent or acquiescence of the government, again, the same mantra, falls outside the scope of Article 3, unless the non-governmental entity occupies and exercises quasi-governmental authority over the territory to which the complainant would be returned. We submit that, especially given that ELMI cited in that paragraph, that must be in the ELMI sense, with the preconditions associated with ELMI, i.e. there being no central government. And that, we submit, is supported by the next part of paragraph 6.4, where the committee said, since the complainant can be returned to territory other than that under the control of the LTT, the issue on which he bases this part of his claim, that he would suffer retribution from the LTT upon his return to Sri Lanka, cannot be considered by the committee. In other words, the exceptional circumstances on ELMI do not arise. There was no central government. There was a central government with jurisdiction and obligations over the whole of Sri Lanka. So the only issue that arose was whether the individual could be whether SS could be returned to a place of safety under government control with the benefit of protection from that government.
Thank you.
But suppose that somebody from the LTTE turned up in the Netherlands and was then accused of those very acts of torture which are referred to in this report, would the Netherlands be under an obligation to prosecute that person?
Not under UNCAT, my lady.
I know you'd say that,
We would say that.
but do the two things have to follow?
Well, we would respect that the criminal jurisdiction under the Convention can only arise in relation to torture that's defined within the terms of the Convention. So plainly not. There may be other means by which the Netherlands could prosecute someone who had committed torture.
Yes, that of course. I am talking about the Convention, but I'm not sure that it follows from the fact that you can return somebody who's been or at risk of torture from the LTTE to Sri Lanka, because you can return them to a place under the control of the legitimate government of Sri Lanka, and therefore they will be adequately protected against this. I'm not sure that it necessarily follows that what's going on in the LTT-controlled area of Sri Lanka doesn't fall within the definition in Article 1 of the Convention, such that the duty to prosecute would arise.
Well,
Two things don't necessarily...
Well, my lady, we submit that they do, because the obligations to prosecute under the Convention come via the definition of torture as set out in Article 1, and it simply, as a criminal jurisdiction, simply doesn't arise unless the elements of the offence are contained within the act of torture. It would be the same, a member of the LTTE turning up in Sri Lanka would be much the same as a private individual who's committed an act of torture in Sri Lanka turning up in the Netherlands. The two are completely the same.
We're back down to this distinction between exercising governmental powers and being a state, aren't we?
Well,
because in the area where the LTTE was in control, they were exercising governmental powers in Sri Lanka, weren't they? That's acknowledged in this decision. But they weren't, of course, the state of Sri Lanka or the state of the Tamil area of Sri Lanka.
And that, we respectfully submit, makes the point, because notwithstanding the fact that they're exercising governmental powers, it'd be very easy for the committee to say, well, look, we can exercise jurisdiction here, and we can articulate this as torture within the meaning of the Convention, because the LTT is exercising governmental powers, and that falls within the scope of the Convention, and therefore we can consider this case under that basis. But they don't say that. In every single case that they considered, they've always said, in relation to non-state entities, even those that are exercising governmental authority or something akin to governmental authority, they've always said that that doesn't trigger and give rise to the application of the Convention. The third issue, Section 134 of the Criminal Justice Act, as we said at the outset, enacted to implement the United Kingdom's obligations pursuant to UNCAT and enable the UK to ratify it. Article 1.2 of UNCAT makes specific allowance for states to adopt national legislation of wider application. There is nothing, we respectfully submit, in Section 134 to suggest that the UK intended the public official capacity to have wider meaning or application than that as contained in Article 1 of the Convention. Section 134 is set out at tab 1, memory stick page 242. Sorry. As I said at the outset, there's no express definition of person acting in an official capacity in Section 134 or elsewhere in the Act. It must, therefore, we respectfully submit, have the same meaning as Article 1 of UNCAT. Section 1341, pursuant to which the appellant is charged for 7 of the counts, and then the conspiracy count in relation to Section 1341, provides that a public official or person acting in an official capacity, whatever his nationality, commits the offence of torture in the UK or elsewhere if he intentionally inflicts severe pain or suffering on another in the performance of his or purported performance of his official duties. As I said earlier, the term official duties is not defined in the section nor the Act, nor is it a term or requirement expressly contained in Article 1 of the Convention. The term applies equally to both public officials and those acting in an official capacity. The official duties of a public official are perhaps obvious, are as also the official duties of someone acting in an official capacity, if, as we say, it is limited to those acting for or on behalf of a state. It is perhaps less clear, however, how the official duties of a non-state actor not acting for or on behalf of a state in the UK should be defined if the respondent is correct with their extended application or interpretation of Section 134 and the official capacity requirement in Section 134. We respectfully submit it is not enough to say otherwise than in a private or individual capacity, even if it is exercising or purporting to exercise governmental authority, because under domestic law and also in international law, the conduct of such non-state actors will always be, we respectfully submit, whether they're exercising quasi-governmental authority or not. They will always be in a private or individual capacity. So if you had a breakaway group in the United Kingdom purporting to exercise governmental authority in, say, for example, Cornwall, that would not, we respectfully submit, amount to official capacity within the meaning of Section 134 and Article 1 of the Convention, because under domestic law, they're plainly acting in a private or personal capacity. They're not exercising official duties within the meaning of Section 134, subsection 1 of the Act. The reference to the term purported performance of duties in Section 134 relates to ultra vires acts, i.e. to a police officer who uses his position of authority to commit torture not sanctioned by the state. It plainly does not refer, we respectfully submit, to someone who claims or purports to be government, but who does not in fact exercise the functions of the government of a state. May I please take you to two authorities in which the meaning of Article 1 of the Convention was considered by domestic authorities, and they're the decisions of EO and the Secretary of State for the Home Department at tab 34, memory stick page 1006, and Medical Justice and the Secretary of State for the Home Department at tab 37, memory stick page 1146. Both cases concerned immigration detention powers and the Secretary of State's power to detain potentially vulnerable people by virtue of, inter alia, whether they were a victim of torture and therefore in need of particular consideration. In 2013, the Detention Rules 35 process, considered an EO, provided that in determining whether someone should be detained, caseworkers who were considering their case were to apply the word torture as used in the Article 1 sense in UNCAT, and that's at paragraph 12, memory stick page 1017. The claimants argued at paragraph 19, at page MS 1020, that it should be given a non-technical colloquial meaning, and the Secretary of State for the Home Department submitted that torture in the detention rules and policy should be given the same meaning as that found in Article 1 of UNCAT. And the issue between the parties was whether it should be limited to pain and suffering by a public official person acting in an official capacity. That's at paragraph 48, memory stick page 1030. Mr. Justice Burnett, as he then was, concluded that the detention rules and policy documents had a broader meaning than the UNCAT definition. And as articulated by Mr. Justice Ousley in Medical Justice and the Secretary of State at tab 37, paragraph 14, memory stick page 1049, it was not confined to the acts by state agents or in which they were complicit or acquiesced. It also covered, as set out at paragraph 82 of ENO at memory stick page 1042, any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for purposes as obtaining from him or a third person, punishing, coercing, etc., for any reason based on or discrimination on any kind. In medical...
So why introduce all the rest of it but leave out the public official bit?
Well,
One could imagine torture had a much broader meaning without necessarily bringing in those particular purposes.
Well, my lady, what was at issue in this case was whether the Secretary of State and its caseworkers were only applying the UNCAT Article 1 definition, and as we'll see, it was held that there needed to be a broader interpretation of that because there were plainly individuals who had suffered torture who didn't come within the Article 1 meaning, i.e. torture committed by states and state agents, that needed protection as well, and should be treated in a particular way, or rather shouldn't be treated in a particular way, i.e. not subjected to certain kinds of detention. And it was therefore felt that the terms for the purposes of those individuals should be expanded. But as we shall see, particularly when we look at the case of medical justice, which is at tab 37, at memory stick page 1049, paragraph 15.
Did you say 1049?
1,000, forgive me, 1,149.
That sounds better.
Sorry, forgive me. At paragraph 15, the UNCAT definition set out later at paragraph 32, minus the words, when such pain and suffering is inflicted by a public official, that became known as the EO torture definition. The issue that Mr. Justice Burnett then was dealing with was whether state actor involvement was required, as articulated under Article 1 of the Convention, for the purpose of the definition of torture in the documents he was considering. In E&O, it was of course expanded, and Mr. Justice Burnett's conclusion was that based on the facts that there were no significant differences between the therapeutic needs of victims of torture in the UNCAT sense and the wider sense, there was an expanded definition, and that became known as the EO sense. If we look at paragraph 32, subsequent to forgive me, my lady. Yes, paragraph 32, subsequent to E and EO, the definition of torture for the purposes of the guidelines spelt out in the Detention Services Order purported to define torture for the purposes of the detention rules to include, torture is defined as, in the bottom of the part of that paragraph, it does not include pain or suffering arising only from inherent in or incidental to lawful sanctions, Article 1 of the Convention of UNCAT. And this is the important, crucial part. It includes such acts carried out by terrorist groups exploiting instability or civil war to hold territory. That is the variant, what became known as the variant UNCAT definition. The reference to acts carried out by terrorist groups is not, it was held, part of the UNCAT definition. This is at paragraph 33. They were added following discussions between the Secretary of State and an NGO, Freedom from Torture, and was suggested by Sir Keir Starmer, MP. Subsequent it is plain, we respectfully submit, that it was determined that the extended meaning was not that contained within the Article 1 definition of UNCAT, i.e. UNCAT did not include acts carried out by terrorist groups exploiting instability or civil war to hold territory. The claimants brought a judicial review on the basis that the definition of torture in the 2016 guidance, even with the extended definition and words, was unlawfully restrictive, in particular with reference to the interpretation by the High Court in EO. Mr. Justice Ouseley held that it was. His consideration of the issues at paragraphs 153 to 158, memory stick page 1174, is, we respectfully submit, helpful. At paragraph 153, the new AARSG guidance was held to be unlawful because it drew a distinction between the variant UNCAT torture, UNCAT plus, and the EO torture, as articulated by Mr. Justice Burnett in EO. Paragraph 54, the chief problem with the UNCAT definition, with or without the variant inclusion of torture by terrorist groups holding territory, is that it excludes certain individuals whose experiences of the infliction of severe pain or suffering may indeed make them particularly vulnerable to harm in detention. Mr. Justice Ouseley was open to persuasion that there might be something inherent in the UNCAT torture that required victims of such torture to be treated in, or rather not treated in, a particular way. He had some sympathy at paragraph 158 for the Secretary of State's point that UNCAT torture, with or without the terrorist group addition, merited particular focus because of what Mr. Novak identified as its particularly abhorrent nature. The reference to Novak was a report by Mr. Manfred Novak in his capacity as the Special Rapporteur for Torture, which is an extract of which, the crucial part of which is set out at paragraph 111 of Medical Justice, which is at memory stick page 1167. The report by Mr. Manfred Novak in his capacity as Special Rapporteur was in a formal role rather, and was advanced in that capacity rather than, and he advanced in that capacity a more restrictive definition of what constitutes torture under UNCAT than he does in his later academic work. Paragraph 111, the 210 report to the UN General Assembly by Mr. Manfred Novak, the question, what is torture? And the crucial part is, it begins, what is torture? The term torture should not be used in an inflammatory manner. It is reserved for one of the worst possible human rights violations and abuses human beings can inflict upon each other. It therefore carries a special stigma. It therefore holds a special position in international law. At the bottom of that paragraph 43, contained within paragraph 111 of Medical Justice, he sets out, according to the definition contained in the Convention Against Torture, 4 elements are needed in order for an act to be qualified as torture. Firstly, act inflicting severe pain or suffering. Second, element of intent. Third, specific purpose. And lastly, the involvement of a state official, at least by acquiescence. And it's of note, we respectfully submit that in that report, in his capacity as Special Rapporteur, he refers to state, the involvement of a state official, at least by
Well, that's just a portmanteau term, isn't it?
Well, my lord, no, because he's obviously using it to cover both public official or person acting in an official capacity. And again, it goes back to all the travaux preparatoires. It's always been understood, we respectfully submit, that UNCAT only does apply to states and state actors. And that is why he uses the term state rather than a state official, rather than the more expanded meaning that he gives in his later academic work. But we submit that what's important to take from these cases is that the Home Secretary's point of view, an interpretation of the Act, an interpretation of Article 1 of UNCAT, it didn't extend to, or it wasn't felt to extend to, groups exploiting instability or war to hold territory. So therefore, in the Home Secretary's view, even where a group holds territory, they do not come within the definition of Article 1 of UNCAT. That, we respectfully submit, is what the UK's position is and always has been since the drafting of UNCAT, that it applies only to those acting for or on behalf of a state. If it didn't, you wouldn't need to have the extended groups proviso that was inserted into the detention guidance. The next two cases that we would respectfully rely upon are Jones and Saudi Arabia and Pinochet number 3. The official nature of torture under Article 1 of UNCAT was considered within the context of claims for immunity in both of those cases. And we accept that the issue under consideration in both of those cases was not strictly whether the term person acting in an official capacity can be given the extended meaning advanced by the respondent. However, we do submit that the outcome of both matters was predicated on after a very careful and lengthy consideration of, amongst other things, the UNCAT Travaux and the distinction between torture under UNCAT and torture as an international crime. In Jones and Saudi Arabia, memory stick page 680, it was held that the very reason that an act of torture under UNCAT must be official is that it attracted immunity under the State Immunity Act 1978. Jones concerned a claim for compensation under Article 14 of UNCAT. Memory stick page 696E, Lord Bingham stated, "It is, I think, difficult to accept that torture cannot be a governmental or official act, since Article 1 of the Torture Convention, under Article 1 of the Torture Convention, torture must, to qualify as such, be inflicted by or with the connivance of a public official or other person acting in an official capacity. The claimant's argument encounters the difficulty that it is founded on the Torture Convention, but to bring themselves within the Torture Convention, they must show that torture was, to paraphrase the definition, official, yet they argue that the conduct was not official in order to defeat the claim of immunity." The same point is made by Lord Hoffman at paragraph 78, memory stick page 711.
Sorry, paragraph?
78,
Thank you.
my lord. It seems thus clear that a state will incur responsibility in international law if one of its officials, under colour of his authority, tortures a national of another state, even though the acts were unlawful and unauthorised. To hold, for the purposes of state immunity, he was not acting in an official capacity would produce an asymmetry between the rules of liability and immunity. And then paragraph 83 at memory stick page 712, the acts of torture are either official acts or they are not. The Torture Convention does not lend them an official character. They must be official to come within the Convention in the first place. And if they are not official enough to come within the Convention, I cannot see why they are not official enough to attract immunity.
How do you say that helps your submission?
Well, if they're official enough to attract immunity, and that has the same meaning as official under the Convention, it is only those acts for or on behalf of a state that we say puts within the scope of Article 1 and under the scope of the Convention. And the same point was made by the full majority, the majority of the House of Lords in Pinochet number 3.
Well, Lord, on the page we've got in front of us, Lord Hoffman at paragraph 80 cites Lord Millett's speech, which is quite interesting. He's saying that the offence is one which could only be committed in circumstances which would normally give rise to state immunity.
Well, my Lord, yes. And that is the position adopted by the majority in the House of Lords in Pinochet. Lord Brown-Wilkinson, memory stick page 918, paragraph A, an essential feature of the international crime of torture is that it must be committed by or with the acquiescence of a public official or other person acting in an official capacity. As a result, all defendants in torture cases will be state officials. And at E, under the Convention, the international crime of torture can only be committed by an official or someone in an official capacity. They would all be entitled to immunity. So it's the same point again. And then we have Lord Millett's page, memory stick page 990, D. Lord Millett sets out the definition of torture, the official or governmental nature of the act, which forms the basis of immunity, is an essential ingredient of the offence. Now, plainly, non-state actors cannot benefit from that kind of immunity. Lord Saville, I won't read it out, memory stick page 979, E to F, and Lord Phillips, memory stick page 1003, F. The only conduct covered by this convention is conduct which will be subject to immunity ratione materiae. If such immunity are applicable, the convention is thus incompatible with the applicability of immunity ratione materiae.
The way they broke the circle was to say that the drafters of the convention cannot have intended that there should be any immunity in respect of this offence.
My Lord, yes. We rely on these statements to show that after lengthy consideration, as my Lord will recall, during the arguments in relation to Pinochet, that the travaux preparatoires of the convention were considered at length during the proceedings before the House of Lords. And after having gone through that analysis, that is the conclusion that the majority of their lordships arrived at, that the convention was only ever intended to apply to those who were acting for or on behalf of the state, which is why the whole problem of immunity arose within the context of Pinochet number 3. The only domestic case in which, other than this one, that has arrived at a different conclusion is that of Zardad, which is at memory stick page 1181, tab 38.
But in both Jones and Pinochet, the court wasn't having to address the circumstance of a non-state actor having control of territory. I mean, they were dealing with very directly with what would only be characterised as state action.
My Lord, yes, I think I acknowledged that before considering both Jones and Saudi Arabia and
yes.
But again, without the risk of repeating myself, but those conclusions were arrived at after lengthy consideration of
the travaux. Yes, thank you.
In Zardad, Mr. Justice Tracy, as he then was, sitting at the Central Criminal Court, memory stick page 1190, paragraph 38, states that he construed the wording of section 134, subsection 1, as not only applying to those who are de jure officials, but also those who are de facto officials. I have construed it, having had regard to the purposes of the Convention and the international authorities which have been drawn to my attention, as including, he uses the term person, acting in an official capacity, those who are acting for an entity which has acquired de facto effective control over an area of a country and is exercising governmental or quasi-governmental functions in that area. Now, the international authorities that he's referring to are ELMI and HMHI, which we've already looked at. The two other international cases that were drawn to Mr. Justice Tracy's attention were the ICTY case of Forenzia and the US case of Kadic and Karic. And that is why, in the remaining time that I have, I propose to look at both the ICTY jurisprudence, in addition to Forenzia, which we respectfully submit puts that case in a broader context and makes very clear that the ICTY, the International Criminal Tribunal for the former Yugoslavia, has always drawn a distinction between international humanitarian law, which can apply to non-state actors within the context of torture arising as a crime against humanity or torture arising as a a war crime in armed conflict, internal or international, and torture under UNCAT, which the Yugoslav tribunal held only applied to state actors. And then we'll come on to look at the US cases and put Kadic and Karadzic in a broader context. The ICTY jurisprudence, torture is plainly prohibited under international law. It's a peremptory norm of customary international law and has an absolute prohibition both in times of war and peace. But in international law, the constituent elements that make up the crime of torture for which someone can be prosecuted are different and dependent entirely upon the convention pursuant to which the prosecution of proceedings are being brought. In terms of international conventions, torture was first criminalised in the Geneva Conventions of 1949. But while torture was prohibited in both international and internal armed conflict, grave breaches of the four Genevan Conventions 1949 only related to, and the crime of torture only arose within the context of international armed conflict. In terms of creating a crime of universal jurisdiction, it only applied in international armed conflict under the Geneva Conventions. And that obligation was incorporated into domestic law via the Geneva Conventions Act 1957. Again, that act only applied to torture in international armed conflict rather than torture arising in internal armed conflict. The next major development, leaving aside UNCAT in 1984, the next major development expanding the scope of internationalizing the crime of torture was in 1993 with UN Security Council Resolution 827, which is set out at tab 8, memory stick page 310. The UN Security Council passed a resolution to create an international tribunal to prosecute those responsible for serious violations of international humanitarian law committed in the territory of the former Yugoslavia after the 1st of January 1991. The statute of the International Criminal Court Tribunal for the former Yugoslavia has a similar temporal limitation in that it only applied to violations of international humanitarian law after 1991. By the time the ICTY was established, the former Yugoslavia had split into separate states, Slovenia, Croatia and Bosnia, and Herzegovina, Serbia, and later Kosovo. Article 2 therefore gave the ICTY jurisdiction over grave breaches of the Geneva Conventions arising in international armed conflict. Article 3 related to violations of the laws and customs of war, including common Article 3 that could be applicable in internal armed conflict, Article 4 genocide, and Article 5 crimes against humanity, which included the crime of torture when committed as a widespread or systematic part of a widespread or systematic attack on a civilian population. The next development was the adoption of the Rome Statute for the International Criminal Court in 1998. The statute is set out at tab 6, memory stick page 298. It gives, in the same way that the International Criminal Court jurisdiction over the same crimes as those contained within the statute of the ICTY. The statute provided for the articulation of elements of crimes negotiated by states rather than by judges, which is what occurred at the ICTY. The ICTY is the first international tribunal since Nuremberg. The judges of that tribunal had the obligation to try and identify what the elements of the various offences were. But by the time you get to the ICC in 1998, the elements of the crimes were articulated as a result of negotiation and agreement between states. And it is clear there that if one looks at tab 7, memory stick page 304, that for both war crimes, either in internal or international armed conflict under Article 8, or crimes against humanity under Article 7 of the Rome Statute, there is no requirement for there to be a public official or official capacity requirement for any of those crimes to be committed. It's either the crime of torture occurring within the context of an armed conflict or as part of a widespread or systematic attack that gives rise to torture in such a context being an international crime. By contrast, UNCAT can only apply to individual acts of torture, and it need not be part of such a widespread or systematic attack or armed conflict, but it is the official nature of the perpetrator as either a public official or person acting in an official capacity that makes torture under UNCAT a crime of international concern. The ICC offences have been incorporated into UK law by the ICC Act 2001, whether committed in the UK or outside of the UK. This represented the first time that crimes against humanity and war crimes in internal armed conflict, this was the first time that such crimes could be prosecuted in the UK if they occurred outside of the UK. But, crucially, Section 65A inserted by makes provision for retrospective application of the UK has only got jurisdiction for torture committed in internal armed conflict as part of a crime against humanity for offences committed after the 1st of January 1991, and that provision was inserted by the Coroners and Justice Act 2009, which is at tab 3. Coroners and Justice Act 2009 also extended the resident condition to include those who are in the UK seeking indefinite leave to remain or applying for asylum, etc. They can be held to constitute residents for the purposes of prosecution under the ICC Act. But the date of the 1st of January 1991 is important because it was chosen to coincide with the jurisdiction of the ICTY. And we start with that to demonstrate that neither at the international level, and certainly not within the UK, could anyone be prosecuted for torture either as a war crime in internal armed conflict or torture as a crime against humanity occurring before the 1st of January 1991. And yet, the respondent at paragraphs 47 to 57 of their written case, memory stick page 112 and 14, invite the court to refer to the jurisprudence of the ICTY as an helpful illustration of how the jus cogents norm has been interpreted so as to close apparent loopholes created by the usurpation of state control by rebel groups during an armed conflict. But until the elements of crimes for the ICC, neither the Geneva Conventions prohibiting torture, the Geneva Conventions did not define the crime of torture or articulate what the elements of torture should be. So when the ICTY came to deal with the offence of torture as a war crime for the first time, it fell to the trial chambers and appeals chambers to articulate what they thought the elements of the crime of torture for war crimes and crimes against humanity should be, and they turned in part, therefore, to the UN Convention Against Torture. We respectfully make 2 points. The first is that the jurisprudence of the ICTY, we respectfully submit, is therefore only applicable to war crimes and crimes against humanity, offences committed after the 1st of January 1991. They are therefore of limited value, we respectfully submit, to an interpretation of what the elements of torture should be before that date. Second, when looking at that jurisprudence, we see that it actually, we respectfully submit, supports the appellant's position that the public official capacity requirement applies only to state actors. The first case to consider the elements of torture as a crime under Article 3 of the ICTY statute was Delalich, which is set out at tab 43, bundle A3, tab 43. Memory stick page 1331. Paragraph 446, we see there that torture is prohibited by the Geneva Conventions and Common Law Article 3, there can be no doubt that torture, paragraph 452, no doubt that torture is prohibited by both conventional and customary international law, human rights treaties. In addition, the trial chamber noted that there are two international instruments solely concerned with torture. The most significant is UNCAT. At paragraph 453, the trial chamber acknowledged that it is jus cogens. At 444, that torture is a norm of customary international law. It further constitutes a norm of jus cogens, as was confirmed by the Special Rapporteur for torture. The ICTY then looked at, the trial chamber looked at attempts to articulate a legal definition for torture under the Declaration for Torture, UNCAT, and the Inter-American Convention. And the trial chamber considered whether there needs to be an official sanction. And at paragraph 473, memory stick page 1339, the ICTY said traditionally an act of torture must be committed by or at the instigation of or with the consent or acquiescence of a public official or person acting in an official capacity. They went on. In the context of international humanitarian law, this requirement must be interpreted to include officials of non-state parties to a conflict in order for the prohibition to retain significance in situations of internal armed conflicts or international conflicts involving non-state entities. It is clear, we respectfully submit, that the trial chamber are not attempting to extend the scope of UNCAT. Rather, they are using it as an interpretive tool to determine the hitherto non-existent definition of torture in international humanitarian law. The next case is that of Forenzia at tab 44. The trial chamber noted that IHL, while outlawing torture, does not provide a definition of torture. Such a definition, it said, can be found in Article 1, subsection 1 of UNCAT. International jurisprudence demonstrates there's now a general acceptance.
Where are you reading? Sorry.
Sorry, this is from
Paragraph.
memory.
I've got Forenzia.
Memory stick page 1359.
1359.
1359, and
Thank you.
over the page at paragraph 161, memory stick page 1361, the trial chamber noted international jurisprudence demonstrates there is now general acceptance of the main elements contained in the definition set out in Article 1 of torture. Paragraph 162, the trial chamber considers, however, that while the definition referred to above applies to any instance of torture, whether in time of peace or armed conflict, it is appropriate to identify or spell out some specific elements that pertain to torture as considered from the specific viewpoint of international criminal law relating to armed conflicts. The trial chamber considers that the elements of torture and armed conflict are, and then they set out 1 to 4, and then the important element is element 5 for our purposes, that at least one of the persons involved in the torture process must be a public official or at least must at any rate act in a non-private capacity, i.e. as a de facto organ of a state or any other authority-wielding entity. What is clear, we respectfully submit, is that the trial chamber was not expanding the scope of the convention, and nor could it.
Would that be a convenient moment at which to pause? You seem to have got to the end of a little section.
My lady, yes.
You've basically got 3 minutes left, so we'll try and get back before 2 o'clock in order that we can...
Not today.
Oh, we're not in this afternoon. No, sorry. I'd forgotten that.
We'll
Sorry
add 3 minutes tomorrow.
We will try and add 3 minutes
Thank
tomorrow.
you very much for
that. Very well.